Good evening and welcome to a special meeting of the Board of Public Works and Safety. My name is Dennis Buckley, Mayor of the City of Beech Grove, and in lieu of a roll call, I will ask each participant to introduce himself, beginning on my far right.
Ed Bell.
Dan McMillan, Clerk Treasurer.
Craig Wiley, City Attorney.
Sandy Seward.
At this time, we'll convene the meeting, and the only topic of discussion this evening is a DPW's approach the city in regards to entering into an agreement with AFSCME Local 62 and Local 1509 and the City of Beech Grove. I don't know if Andy or Rod, if you want to talk about how this has led to where we're at tonight, and then we'll get started in the presentation.
Well, it started just as the guys getting together and wanting to start, participating in the union. So we got a hold of Jay, talked to him a little bit, kind of liked what he, was saying and how it would benefit us. So we, came forth to you guys, or the city council, proposed it. It passed. So then we sat down and talked about different, things we'd want in the agreement and how we thought it would better our workplace, both for us, for Brad, Merriweather. So we kind of just, put this together, and hoping that it would just better everybody's position, help out with different areas I don't think were covered in, handbooks, things like that. There's some things that are kind of vague that we tried to spell out, I guess, here and make it a little more in depth. So that's kind of where we are, I think.
Andy, you want to add to that as far as meetings that have been held and who's attended the meetings?
Yeah, we've had meetings and things over there at Public Works. It's typically been myself, Jay, Rodney, you, Mayor, and Brad, Merriweather, things, and we've also sat down and I think had some very constructive meetings and things and come to agreement on a lot of these issues and things that we've raised and taken together with the contract that we can all agree upon and things.
And I did not include the other two board members in any of these meetings, because if I would have had to advertise it as a public meeting. So that's the reason why the other two board members have not been part of this process. I do want to correct something, Rod. You said it passed. The council did not approve the thing. That was defeated. There's 10 employees of DPW, 9 employees assigned, what do you call that card, Jay?
A card of intent.
Intent. So if over 51% of the employees did that, then that requires recognition. So that's where we're at tonight. So what I would like to do, and we're going to just go back and forth with the board and you folks. We'll just start with the agreement and work through it. And anytime that a board member has a question or a concern or doesn't like what he or she reads, this would be the time to talk about it. Go ahead. We'll go ahead and start. And Andy or Rod, we'll let you take off. And sure.
Okay. This agreement, the agreement, is between the City of Beech Grove, hereinafter referred to as the city, on behalf of the Department of Public Works, hereinafter referred to as DPW or the department. The general purpose of this agreement is to set forth the salary and benefit structure applicable to full-time employees of the city, hereinafter referred to as members of the department, and to promote orderly and peaceful labor relations for the mutual interest of the city, its employees, and the American Federation of State, County, and Municipal Employees, hereinafter referred to as AFSCME or the union. The terms hereof are intended to cover only minimums and wages, working conditions, and other employee benefits. The city may place superior wages, working conditions, and other employee benefits in effect. Witness, that to facilitate harmony and efficiency to the end that the city and the ASME and the general public may mutually benefit, the city and the ASME have the following understanding. Article 1, Period 1 of the agreement, Section 1, the duration. This agreement shall take effect January 1st, 2014, and shall continue in full force and effect until January 1, 2016. And we also have an addendum at the back in regards to the duration there. Section 2, future negotiations. The parties agree to begin negotiations for a new agreement no later than May 1st, 2015. Section 3, extension. In the event the parties are unable to reach a new agreement before the expiration of this current agreement, the terms and provisions under the current agreement shall remain in full force until a new agreement has been reached. Section 4, renegotiation of agreement. Notwithstanding any provision herein to the contrary, it is understood and agreed by the parties hereto that any provision contained in the agreement may be amended at any time by the mutual agreement of the parties hereto. Section 5, severability. In the event that any provisions of this agreement are found to be inconsistent with state or federal statutes, the provisions of such statutes shall prevail. If any provision herein is found to be invalid and unenforceable by a court or other authority having jurisdiction, then such provisions shall be considered void and shall be served or severed from this agreement. But all other valid provisions shall remain in full force and effect. The parties hereto agree to notify the other of any ruling in this regard. Article 2.
Can I stop you right there?
Yes, go
Can,
ahead.
can we like make comments along the way, or do you want him to read
Sure.
all through it first?
Well, why don't we wait until, like, he does a section, at the
Okay.
end of the section?
Okay. Can we go back?
Well, sure.
Okay, let's go back to the preamble, please. It talks in here, in the second sentence, the general purpose of this agreement is to set forth the salary and benefits structure. It's my understanding that there aren't a salaried employees, they're all hourly wages. So it kind of says that throughout this entire document. So we need to change that salary to hourly wage. And I'm fine with Article 1, period of agreement.
Okay,
So starting with Article 2.
continue with Article 2.
Thank you.
Conditional recognition. The Beech Grove Board of Public Works and Safety recognizes the ASME as the exclusive representative for members of the department. The ASME shall be the exclusive representative for the purpose of meeting and conferring with respect to salaries, employee benefits, and appropriate mutual concerns within the DPW. The city shall not negotiate with or make any collective bargaining agreement or contract with any other employee group.
Could we go back
Yes, sir.
to Article 1, because we sped up real quick.
Okay?
In Section 5, you were saying the event that any provisions through this agreement are found to be inconsistent with state or federal statute. Well, the city does make ordinances too. I would like to see if would have the city be put in that too. I understand it'd be a negotiation type situation, but exactly.
Contract.
So you want to say city, state, or federal statutes?
Correct.
Okay.
city ordinance.
City ordinance.
Do you have any others, Ed, for Article
No.
1?
We're
If
fine
we
there.
Go to Article 2, that very, which is on page 2. The very first sentence, the Beech Grove Board of Public Works and Safety recognizes, I think that should be the city. The city recognizes AFSCME. Thoughts? Concern?
Well, I don't say there's a concern. It says Beech Grove Board of Works, which would be
That's
city.
you and I. There's more
Well, that's
than
true.
just you and I.
That's
I think
true.
it should be the city.
Okay.
And also the very last sentence, the city shall not negotiate with or make any collective bargaining agreement or contract with any other employee group. Do we need to define employee group? What other employee group is there?
We're talking about other unions or other union groups.
Within the city or outside the city?
Anybody.
Okay. So does it really need to be defined, just employee group? Okay.
Continue to Article 3. Article 3, committees. Section 1, Labor Management Committee. There shall be a Labor Management Committee consisting of 2 employees from the ASME and the DPW department head. The committee shall meet on request by either party or at least once a quarter to discuss matters of mutual concern. The committee shall have authority to make recommendations to the ASME and/or the Board of Public Works and Safety if a committee member comes in on his/her off-duty time. The member shall be granted overtime pay or compensatory time. Section 2, Health and Safety Committee. There shall be a Labor Management Committee consisting of 2 employees from the ASME and the department or the DPW department head. The committee shall meet on request by either party or at least once a quarter to discuss matters of mutual concern. The committee shall have the authority to make recommendations to the ASME and/or the Board of Public Works and Safety. If a committee member comes in on his/her off-duty time, the member shall be granted overtime pay or compensatory time. Questions for Article 3?
Now, we're talking representatives, would that be a union
Probably,
rep or,
like the union stores at the shop, you
Well,
know, that kind of thing.
okay, that's what I was,
It wouldn't be like Jay, it would be one of us that
okay,
have to say, yeah.
all right.
So when you're talking about the Labor Management Committee and the Health and Safety Committee, those are yet to be defined? Is that way, is we yet to be defined and once, okay, once it gets up and going? Okay, okay.
Article 4, ASME and city rights. Section 1, ASME rights. Okay. And then, under union recognition, we're gonna change that first line there, change it to the city. As we talked about before. The city recognizes the ASME, Indiana Council 2, as the exclusive bargaining agent for all regular full-time employees at the Beech Grove DPW. The parties agree and understand that this unit shall not include management-level employees, supervisors, seasonal, part-time, or temporary employees. B, union membership. All regular full-time members of the DPW are eligible for union membership status and voting privileges in the ASME. C, dues checkoff. Upon receipt of a voluntary, written, current, signed authorization in such form as complies with the laws of the state of Indiana, Indiana Code 22-2-6-2, from a member of the DPW, the city shall deduct biweekly from the earnings of each such employee an amount representing regular monthly dues for the preceding month. The city of Beech Grove shall remit such monies, together with the appropriate records, to ASME Council 62. The city shall not be liable to the ASME for failure to make deductions for dues. In the event of an overcharge already remitted to the ASME, it shall be the responsibility of the ASME to adjust the matter with the employee. The ASME will indemnify the city and hold it harmless from any and all claims or liabilities that may arise under this paragraph. D, unit work. DPW employees excluded from the bargaining unit as set forth in Article 4, subsection A, shall not be used to perform work normally done by the bargaining unit employee, as this results in the loss of pay and overtime compensation for the bargaining unit employee. However, it is understood that employees excluded from the bargaining unit may perform the work of the bargaining unit employee in the following situations. 1, during an emergency, defined as an event which is not routine or which could not be reasonably anticipated. Example, a snowstorm, tree falling in the road during the middle of the night, etc. 2, when bargaining unit employees are not available to perform the necessary work, or after management has attempted to inform the bargaining unit employees that such work is available. E, union representation. The city recognizes the right of the union to select designated union representatives and alternates to represent the employees in disciplinary meetings, grievances, and in safety or labor management meetings. A listing of the on-site union representatives and alternates shall be posted on the break room bulletin board. F, access to personnel files. The DPW head shall maintain a personnel file for each member of the department. Each member shall be allowed to examine the contents of the member's personnel file during regular working hours in accordance with applicable law. Employees of the department shall receive copies of materials contained in their personnel files upon their request and within a reasonable time. Employees of the department may not remove any document from their personnel file, but may respond in writing to any data believed to be inaccurate in accordance with the procedures set forth in this subsection. The union representative's employee shall be notified and discuss any additions to be potentially added to the employee's personnel file.
Since this section's so long, can we just take one page at a time? Are you okay with that?
Yeah.
Okay. So just for clarification, I mean, it's clear to me, but just for purposes, you do not have to be a member of the union, correct?
No.
If you choose.
Not mandatory.
Not mandatory, okay, good. And on the dues, check off section C, where it says the city of Beech Grove shall remit such monies together with the appropriate records. Can we define appropriate records? What are you asking for here?
I think that would come from the payroll department, well, like the name, and the amount of the dues, and possibly the department they work in. And maybe, I mean, sometimes it's a higher end date, but that stays consistent.
Right, okay. All right. And section F, access to personnel files. The DPW head shall maintain a personnel file. I think we need to say the director or the DPW director and/or mayor. If for some reason the director is I don't know, on a leave or a vacation or vacates his role, then I think somebody needs to be able to have access to these records. Thoughts, comments?
Well, when the employee is hired, they automatically have a personnel file.
Right.
And it's down here. But I don't know if they're talking about here, if they're talking about for discipline. Because I don't know if you're ever going to access your personnel file after you're hired, but you would want to access your personnel file for evaluations or discipline.
Right.
Is that what you're talking about?
Yeah.
So are you saying it should just be the DPW director? Period? Okay.
Well, also, should we have in there, may be individual that elects not to be in the union? Well, should you be able to get into their personnel file?
What's your question?
Well, not all employees may decide to go with the union. So would there be any reason why you would gain access to their,
It's the individual. The union wouldn't be getting into anybody's file unless the individual wanted them to anyway. We're not gonna have access to anybody's file unless they come to us and say, look at it with me. We're not stating that we're gonna look at just random files, by no means. It would be on their request, not the union's request. It's just a union employee.
So you would just represent, you would just be representing
It's
the
not-
employee?
No one's gonna look into the, employee's files.
Sure.
Just to look into it. It's only at their request.
okay.
So yeah, I see what you're saying, but yeah, we're not gonna look at just looking files.
Right.
It would be at their request.
Okay.
Yeah.
Do you wanna, is there something?
I would like,
you need to
I
add?
got-
could we shoot at the employees?
Hey, Brad, could you come up for a minute? What happens now
In regards to,
if somebody wants to look at their file?
I don't think I've ever had anybody request to look at it, but I don't think there's any policy that would inhibit somebody from being able to see what was in their file.
We've had people come to City Hall and ask to look at their file. Basically, it was more for insurance purposes, to change a beneficiary, marital status change, whatever. So, I mean, they're open to them now, so, but it would only be open to the person whose file it belonged to. It would not be open. Like Andrew couldn't come and ask about someone else's file. He could ask about his own anytime.
Yeah, I don't think the intent is to be able to browse anyone else's, what's happening with them or whatever. I think people would just want access to their own, to maybe review, like the mayor mentioned, a review or something like that.
But I guess what my point was, if you were unavailable and somebody wants to get into their file, should there be that secondary person?
Yeah, I mean, John or, there's always access to my office where those files are. I don't know if there would be some formal process of requesting it or if it would just be, make sure someone's there so that they know you're only getting yours. But I don't think the place is ever without some kind of supervisor of some sort. So I don't think it'd
You
be
would
a.
not have a problem with if you were on leave for whatever reason, and if someone wanted to see their personnel file in the union and that person got into your files
Yeah.
and went through that, you would be okay with that?
Yeah, I don't think I have a problem with that.
There. Will you stay there? I have another question for you, please.
Sure.
So, still in section F, where it talks about employees of the department shall receive copies of materials contained in their personal file upon request within a reasonable time. I think we need to define reasonable time, because your reasonable time and my reasonable time might be two different things.
True. Yeah, I mean, that would be something that I guess we could work out as what we would define as reasonable. I don't have any strong feelings about it as far as a day or within a day or 2 days, whatever,
Yeah,
whatever I
I
guess
mean-
suits the needs of both parties.
Within 48 hours, I would say it'd be reasonable myself, but.
Yeah, I was thinking 10 days, so you
But,
see, we're
yeah,
just,
exactly.
this is why we need to,
Exactly.
kind of spell this out a little bit, so.
Yeah.
Yep.
I mean, what do you think, Brad? We could jot something down here now. I mean, 48 hours.
Yeah, I think that's fair. And you're talking about just a copy of a document that would be provided to the employee or access? Yeah, I wouldn't see why it
You
would,
already have on hand, nothing you have to look up.
yeah, I don't think it would ever take longer than that
Okay.
unless there was some extreme circumstance where
But
we
you know,
were.
you never know. I mean, that's why we're doing this.
Yeah.
It should be defined.
And you may define it as business hours or business days so that you're not including the weekend,
2 business days.
yeah.
Yeah, because somebody asks on a Friday,
Okay.
48 hours falls on
Business
Sunday.
days, that way it's gonna be Friday, Monday.
Yeah, that's fine. I think 48 is fine.
Business days?
Two business
Are we agreeing
days.
with that, gentlemen? 2 days, 2 business days?
Yeah, I mean, I think that's more than enough time to provide something, so.
I keep going?
Oh, sure.
Okay. The next paragraph, the union representative and employees shall be notified and discuss any addition to be potentially added to the employee's personnel file. I think it should be, union representatives and employees shall be notified by the director and discuss any additional additions to be potentially added to the employee's personnel file. Okay? Shall be notified by the director. Again, just kind of defining a little bit of the who's.
Sure.
Okay.
I'll continue with G, union meetings. The DPW/ASME employees shall be allowed to hold regular and special meetings at DPW facilities and may post meeting bulletins and notices on the bulletin board. A 24-hour notice shall be given to the director of the department prior to all meetings that may conflict with work hours. Every effort will be made to plan meetings at times that do not conflict with workflow. H, voting. The ASME members shall be allowed use of DPW facilities to hold general elections. I, Association Business League. All ASME business and activities shall be conducted on the employee's own time and shall not be compensated by the city, except as specifically set forth in this subsection. Members of the Labor Management or Safety Committees, Grievance Committee, and ASME officials shall be granted reasonable leave from duty with pay, but not overtime pay, for the purpose of processing grievances, attending committee meetings, or renegotiating the terms of this agreement or any renewal thereof. Such leave shall be requested 24 hours in advance and subject to approval by the director of the department. Also, the president or designee of the ASME shall be granted reasonable leave to perform necessary functions, including, but not limited to, attendance at regular and special meetings, conventions, seminars, conferences, and department-related activities, provided it does not interfere with the overall operations or manpower of the department. Leave for such activities shall be requested no less than 72 hours in advance and shall be subject to approval by the director of the department. J, electronic media usage. Members of the ASME Local 1509 shall have full use of city computer and its systems for the express purpose of obtaining employee information on programs provided by the city for its employees. K, on-site union office. The on-site union office shall be its own locking room, separate from the management or supervisory personnel. The city shall provide a desk, a working computer with internet, a telephone, filing cabinet, and bulletin board. L, union bulletin board in break room. A bulletin board shall be installed by the city in the break room for the use of the ASME to notify its members of upcoming city and union events of importance. M, union parity. The ASME will receive as good or greater wage and benefit increases as any other organized or representative group of employees.
I thought K was taken out.
I think we had some discussion with that, and we talked to Brad as well about it, I believe, at one of our last meetings. There is a room there in the midst of the offices, I believe it's in between John and Brad's office, that's vacant at this point and things. And that was a room we were going to use to have an office area there. And one of the main things for having the office area too is, you know, if an employee comes to Rodney or myself or whoever the representatives will be and things and needs to discuss a matter of some of that nature, we can have an area to discuss things with them and hopefully resolve a situation and that thing before we would go into, you know, meet with Brad about it and that kind of thing.
Well, why should the city provide, you know, a working computer, internet, telephone? I mean, I would think, you know, if it's the union should put, you know, in for that. I mean, it's,
Just 'cause it's
it
a-
just doesn't make sense. I mean, you're wanting the union, so the union should provide some for themselves, you know, to help. It's, everything, it looks like it's
Yeah.
city given here.
Yeah. I think that, you know, as far as the union for us is their sole thing is to be a representative for us.
But they're collecting dues though.
Do you want to strike K?
I mean, would it be, if we got an available room, would it be okay to at least have a room to where we can, you know, meet with employees and things like that if there's, you know, concerns?
I mean, does
Giving
it,
employees some privacy versus discussing issues.
yeah,
in the
and I
open.
get that. I think we should provide, you know, a room or a conference room, but to have your own locking room
Yeah.
and a desk and a computer with the internet and the telephone and a filing cabinet and a bulletin board,
I don't see why we need to do all that.
all we need is a room.
L, aren't you going to use the same one as the work orders?
Yeah, we can, yeah, as long as we can have space and things.
Yeah, that's currently,
So you would need to clarify L.
okay.
I mean, I will agree that I think you need a bulletin board, like a glass enclosed bulletin board with a lock and key. You ever seen one of those bulletin boards that has a lock and a key on it? I mean, that way people aren't taking things down that should be up or things like that, but
They have a board out there that they put all their work orders on, plus their, all their comp vacation hours and stuff like that. And nobody ever goes in there except for the employees of DPW, so.
I mean, it's just like downstairs, we've got a bulletin board, it's not enclosed, we post all of our meetings, and it works just fine.
so are we gonna discuss that further? Are we taking it out?
I think we can strike K out. Cause I think we'd be fine just to, I wouldn't see Brad having any issue with us if we needed to discuss something, you know, allowing us to use the space that we didn't actually have to, claim as our own. Yeah, I think we'd be fine. Right. Yeah, I don't think he'd have an issue
Yeah.
with that. Yeah, so I think we can do away with that. The only thing, and you said it's some sort of, all I guess we would really like to have that we kind of want would be some sort of maybe filing cabinet, something to lock, you know, if there was files or something we needed to put away at the guys, I don't know. I mean, what we think about that, but we could strike K out of it, I think.
I don't see any problem with a filing cabinet, and it could be in
It could be in
Brad's
office,
room, and
that always,
he wouldn't have the key or whatever.
I mean, if we could just go with that, I would be
Okay.
with that.
Let's see if we can recycle. Let's not go buy new
No,
phones.
no.
Right. Yeah, I think we've got
Okay.
something out,
Yeah,
I'm
there's
sure.
Probably plenty laying around.
All right.
Can we talk about, let me hold. Okay, let's go back up to association business leave. We were talking about such leave shall be requested 24 hours in advance. And then we have at the very end, leave for such activity shall be requested no less than 72 hours. You know, Brad, this is on your dime. Are you okay with this timing? Does this timing work for you? Because you're the department head.
Yeah, repeat again exactly what you were asking.
It's the association business leave. Let me back up here. Members of the Labor Management or Safety Committee, Grievance Committee, and AFSCME officials shall be granted reasonable leave from duty with pay, but not overtime pay, for the purpose of processing grievances, attending meetings, and renegotiating the terms of this agreement or any renewal thereof. Such leave shall be requested 24 hours in advance. Are you okay if it's a extra heavy work week and they're going to come to you 24 hours and say, hey, we got to be out for this meeting?
Yes, I mean, well, as long as I think there's some discretion, I think on John or my part where, you know, if you are in a situation where the work is obviously coming first, I'm sure these guys would be willing to work around that, I would hope, or maybe you need to add some language that gives us that flexibility.
At the end of that first paragraph, it does say that it's subject to approval by the director of the department.
Okay.
So we're waiting on.
If there ever was a situation, I mean, you could hold him to that 24 hours. That's why I just want to make sure that that was kosher with you. Okay. Okay. So as long as you're okay with it, Brad, I'm okay with it. And the 72 hours as well. Okay. Can we jump to G, back up to the top of the page? Sorry, I'm jumping around a little bit. Union meetings. 24-hour notice shall be given to the director of the department prior to all meetings that may conflict with work hours. So, to me, your union meetings should not conflict with work hours. We need the employees like out in the field.
I mean,
doing
don't
their
you have
regular job.
regular union meetings? You're just talking about something special, aren't you?
Right, I mean, if something special come up, I mean, just like in the morning, you know, there's times that are allotted that we have someone come in to present a certain service that they want to offer the employees or something like that, you know, there's maybe a half hour or something like that allotted in the morning, but I guess that'd just be if something special kind of came up, but it's not, I don't think it's anything where we're looking to, hey, we need half the day to have this meeting, you know? And I would hope that those things could obviously be taken care of.
I would think it would be nice if you have regular union meetings and you have something to sell or companies to come in like Aflac or something like that. It'd be in your own time rather than the city time. I mean, you know, unless you'd have a special like a grievance, which we're talking about something different than just a regular union meeting.
Sure. Makes sense.
Right. So I don't know if we really need, I mean, you do have, you know, special meeting in there.
I think this all here is kind of a direct copy too from police and fire contract as well. This is a paragraph that's in there.
But police and fire have backup.
Mm-hmm.
If there was an emergency, police and fire do have a
You
backup.
don't really have any
We don't have really a
backup,
backup for you,
True.
right?
you know? I mean, we don't have to mirror everything on police and fire. It looks like that's what we do all the time. Or they're playing off each other. So I don't think we need to have this playing off with police and fire.
So,
So we're gonna strike G and leave in I for, I mean, because grievances and things is a different.
Grievances is totally different.
Right.
You can't call that a union meeting.
Okay, but but we understand that could happen during the work.
Well, yeah, I can understand that, but union meetings is more of a business meeting between you and the union wanting to, whatever you want to do, but I don't think
Right.
it should be,
Because the sentence says, shall be allowed to hold regular and special meetings.
right.
Regular meetings could be once a month, and special meetings could be, you know, as they come up, so.
I would like to strike it unless we rewrite it.
we're okay with that.
Okay.
got a question on grievances. Do you still plan on using the Board of Works for grievances, or just go
Yes,
through the
yes.
union?
Yeah, that'll be part of the process, exactly.
Okay. So it's basically the same as it was, except for you guys want to review your own union grievance? Am I correct in assuming that?
No, it'll be a process in the grievance process, and the board would have input on resolve that as well.
Only to come to a resolution, right? If the two parties can't work it out, then we would be the next step. Is that what I'm hearing you say? Okay, good.
That'll be coming up as well. We'll go through that step by
Okay.
step under the grievance procedure.
Okay.
They'll outline that for us. Continue with section 2, city rights. Is that okay? City rights. The city, on its own behalf and on behalf of its citizens, hereby retains and reserves all powers, rights, authority, duties, and responsibilities conferred upon and vested in it by the laws and the Constitution of the State of Indiana and of the United States. Executive orders issued by the mayor and any resolutions passed by the Board of Public Works and Safety. Further, all rights which are ordinarily vested in and are exercised by employers in the state of Indiana are reserved to and remain vested in the city, including, but without limited, the generality of the foregoing the rights. A, to manage its affairs efficiently and economically, including the determination of quantity and quality of services to be rendered, the discontinuance of any services, material, or methods of operation. B, to introduce new equipment, methods, machinery, or processes, change or eliminate existing equipment, and institute technological changes beside the materials, supplies, equipment, and tools to be purchased. C, to subcontract or purchase any or all work, processes, or services for the construction of new facilities or the improvement of existing facilities. D, to determine and change the number, location, and type of facilities and installations. E, to determine the size of the workforce, increase or decrease its size in compliance with all applicable legal requirements. F, to hire, assign, and lay off employees, to reduce the work week or the work day, or effect reductions in hours worked by combining layoffs and reductions in work week or work day, or altering assignments or schedules of the department employees. G, to direct the workforce, assign work, and determine the number of employees assigned to operations and administration in their assignments. H, to establish, change, combine, or discontinue job classifications and prescribe and assign job duties, content, and classification for all personnel. I, to establish wage rates for any new or changed classification for any personnel. The president of the ASME will be notified and may request discussions and submit input on the establishment of these wages for personnel covered by this agreement. J, to establish work schedules and to change those work schedules as desired from time to time. K, to establish work and productivity standards and to change those standards as desired from time to time. L, to establish, maintain, revive, and enforce standing orders, rules, regulations, procedures, policies, and standing operating guidelines for the administration of the department.
Could you, you didn't really read anything else in the bold print for just the citizens, and you say meet and confer. Could you spell that out
Okay.
to make sure we're perfectly,
Okay, I believe on those points, there's probably about 4 of them through there, 4 or 5 of them.
Correct.
At the end on some of those, it says meet and confer. Like the one here, point E, says to determine the size of the workforce, increase or decrease its size in compliance with all applicable legal requirements. Just the opportunity to be able to sit down and talk about, the number of employees that we feel that we need in order to get the work done, and to be able to sit down with management and those things over. That's what meet and confer means.
I think what you're saying, Ed, it was in the section E, F, G, and H, and K all have meet and confer.
Right.
Yeah.
So I would want to make sure that everyone knows
Okay.
that that's what you're referring to.
Okay.
We're skipping, you know,
Okay,
want to make sure that's a good point.
okay.
All right.
I do have a question. To establish wage rates, is it displayed, where is it displayed, your wages per hour? Is it in the handbook?
No, where it's displayed would be the salary ordinance.
Okay. Okay, thank you.
Continue with page 7, letter M. City writes, to discipline and discharge employees as provided under applicable laws. N, to adopt, revise, and enforce working rules and carry out cost and general improvement programs. O, to transfer, promote, and demote employees from one classification, division, or shift to another as provided under applicable law. And the meet confers on the end of that. P, to select employees for promotion or transfer to supervisory or other positions, and to determine the qualifications and competency of employees to perform available work, all as provided under applicable law. Meet and confer. The city has the right to random drug testing and driver's license checks. And then C, General Ordinance 6 and 11. And do you want me to read those ordinances? Means they're passing things already, or?
I don't think you need to do that,
Okay.
but now, once you finish through that, there isn't anything on the rest of it that says meet and confer. So that means the city has a free ride on determining any of the other, you know.
I think the meet and confer does that as well. It's only to sit down with management and say, well, this is, or management, so this is what we're going to do. And then we have an opportunity to say, well, you know, this is how it's going to impact us. You know, I mean, it's not an adversarial thing. It's what can we do to make it work?
Okay. All right, thank you.
Okay, when we talk about random drug testing, so we talked about this a little bit, so do we also file or follow a DOT regulation as far as drug testing for those who hold a CDL license?
Yes.
Okay,
And also I wanted to add in there, it says General Ordinance 6 and 11. It's also Ordinance 9 is involved in that. And I think it just got to write it in there, but.
and what about probable cause drug testing?
I think that's a given, or maybe not a given, but it's definitely, that's standard.
Are you talking about, Sandy, are you talking about if the department head feels the employee's acting weird?
Yes.
Yeah.
Okay.
Are you wanting that written in, or does that just fall under randomly drug tested? I mean, is it
I don't think it needs to be put in there. I think it's understood.
just under random?
Section 3, no work stoppage or lockouts. As the services performed by the employees covered by this agreement are essential to the administration of the department and to the welfare of the public dependent thereon, the AFSCME agrees that in no event whatsoever will the AFSCME or any of the employees covered by this agreement initiate, authorize, sanction, encourage, support, or engage in any strike, slowdown, work stoppage, sick out, or otherwise cease the continuous performance of their duties as scheduled. The department agrees that no lockout shall take place during the term of this agreement. The AFSCME acknowledges that any conduct that violates this section threatens irreparable harm to the public. The AFSCME shall have no liability for unauthorized activity by employees in violation of this section, and agrees to immediately make a vigorous and bona fide effort to end all such activity in the event of a violation of this section, including written notification to each offending employee that his/her activity is unprotected and is not authorized, supported, or ratified by the AFSCME. Nothing contained in this agreement shall limit or prevent the ability of the city to discipline an employee who engages or who is believed to have engaged in such conduct contained within this section. Section 4, financing of the contract. If the city's lack of ability to finance the AFSCME contract shall arise, a review of the up-to-date certified budget shall be assessed by AFSCME. Providing the financial shortfall has been proven and agreed upon by both parties, AFSCME will not suffer a loss of wages or benefits greater than any other union-represented employee of the city.
I have a question. Going back up to the top, where is the disciplinary process written? Is it in the handbook? Is there a disciplinary
Yes.
process?
In the
It's in
handbook.
the handbook, okay.
Ed?
My only correction on section 4 is a spelling of review.
We saw that. We saw that.
I figured that.
Article 5, discipline, grievance, and arbitration procedure. Section 1, definitions. The grievance is an allegation that the terms of the agreement or department policy between the union and the city have been violated. B, days. Are business days Monday through Friday, excluding holidays, unless otherwise noted in the agreement. C, supervisor is a supervisor or other DPW management official designated by the city to handle the step 1 portion of the grievance procedure. D, union representative shall be defined as chief representative, representative, or alternate representative. Section 2, union representation. If a bargaining unit employee is to receive discipline in the form of verbal counseling or a written version, the person issuing the discipline shall inform the union representative or alternate of the infraction before the meeting is to be held. The bargaining unit employee may then choose to either have or not have union representation in the room at the time of the disciplinary meeting. Section 3, discipline. Disciplinary files. Any verbal form of discipline shall be removed from the employee's record and or file after the period of 6 months, providing the infraction is not recommitted. Section 4, second chance. If an employee tests positive for alcohol or illegal drugs, they will have a second chance as set forth below. The language of either A or B must be compiled with, or the employee will be subject to dismissal. Comply with. A, in the interest of addressing drug and alcohol illnesses, when an employee tests positive for illegal drugs or alcohol, he or she shall be suspended without pay for 30 calendar days as a condition of his or her return to work. They shall participate in a city-approved drug and alcohol program. Employees shall provide proof of the agency of the employee's compliance with the program's requirements, including regular attendance and treatment recommendation. During the 30-day suspension period, the employee will not be paid benefits or accumulate benefits from the city. B, if an employee tests positive for a legal drug, the employee will be required to take a second test at the discretion of the agency upon his or her return to work following the suspension period. If the results from the second test are negative, then a written reprimand will be issued for the initial positive test. If the results of the second test are positive, then all parties agree that a discharge under this provision is a discharge of just cause.
Okay, hold there.
I'll
Go
start.
ahead, Sandy.
Section 3, as far as discipline goes, and that's going to stay in the file or be removed from the file after 6 months. How would you address those who do the same thing every 180 days? Or, what about your habitual offenders? Do you think, depending on the severity, maybe some of those things should stay in the file? How would you address those habitual offenders every 180 days?
Obviously, maybe that could be like a meet and confer type thing, to where obviously that we're seeing that there's a habit formed, from a certain employee, what have you, where management and the union representative could come together and say, hey, look, we've got this issue, we're seeing it, going on and on, kind of thing.
Ed, how do you feel about that? I mean, doesn't it get old after, it could happen, it might not, but I think you need to be covered.
Well, Sandy, just to follow up on that, a verbal warning according to the employee handbook is the first process. So in 6 months, if you do it, you got to start the entire process over. So I don't see how that would be beneficial to anybody. All it would do is save that employee's job time after time when he's a disciplinary problem, because by the time you get into that procedure, time after time, that 6 month period could be up.
But
I'm not so sure. I think that the written it's not written, it's a verbal. I'm talking with you with regards to your attendance or coming in late, and that is, I'm writing it down because we've had this conversation. I'm not writing you up. I'm telling you that you need to address this and correct it.
Okay.
And so it's not for a severe infraction of policy or rules or anything like that. So it's sort of like, I'm asking you to do something about this, and I'm not gonna write it down, so
Right.
that I know and I remember we've had this conversation once before already.
Right, so how can we define that a little better?
Well, also
For
keep in
corrective
mind
action?
that the department has the right to skip the order. Yeah, the department head does not have to do a verbal reprimand. He can go right to
They
written.
could jump ahead depending on severity.
Section 4, second chance,
I don't agree with that either.
To me, I think the city of Beech Grove, this here, it's like we're telling our employees it's okay to go out and hit somebody in a truck and it's okay, we're gonna pat you on your back and bring you back. That's my opinion.
Well,
No
I
second
agree.
chances.
I mean,
If you have a drug or alcohol problem, we have an EAP.
yeah, that, especially drugs, but alcohol, they say that maybe is a sickness, but, drug overdose, stuff like that. If you're wanting to do something like that, I could see maybe a separation, maybe, alcohol versus illegal drugs. Illegal drugs mean that, but I don't think we
They're
should
both-
separate it. It should be no second chance.
And,
Yeah,
I agree with that.
I mean, we're fine with that not being in there. I know in the past there has been, an issue with a certain employee, what have you, and basically the city did do that kind of second chance program with them and said, go to, counseling, what have you, and try to reestablish the employee. But, we're fine with striking that from that.
You're gonna get the same protection anyway because it's in the employee handbook. Something very similar to it.
Right, and I have that noted in the employee handbook. I guess it's not written out this way in the employee handbook. I think what we tried to do here is we tried to make something vague, not so vague, I guess, is all it is. Because in the handbook, it's just a really vague explanation of what happens. So I don't think we have a problem striking this. I guess the question is what what does the rule book actually say? I mean, what's the actual policy? You know what I mean? I guess that's it. I don't think, in the group of guys we got, I don't think anybody would complain about striking it. I mean, we don't have it in here because we think there's guys that need it. It was just to try to make something that was so vague
Sure.
spelled out, and that's all it was. It's not something trying to be snuck in because there's anybody
Oh, sure,
that I think
yeah.
has a problem at all.
Right.
You know, this hopefully it will never get used. I don't think it will for the guys we have. But that's all. That's all it was. You know, what I mean, so that was our issue, because I think there's like 4 or 5 sentences in the rule book about, you know, they would be disciplined, and then it would be, I think there said something about you would, you know, upon later, I don't know, I can't remember what the wordage is. I wish I had it in front of me, but I don't. It's just vague, and I think that's why I wrote it in there, so I don't know if there's.
Well, the council is currently, one step at a time, rewriting the employee handbook, and that be definitely one we'll probably be addressing, so.
Okay.
But, you know, so I, for one, did not want this in here.
You know, there is, if you come to work drunk, you're subject to termination, right?
Right.
If you come to your boss, you come to Brad and say, Brad, I got a problem. I need help. That's a different issue, right?
Okay. Right.
I think that's probably what that means.
Right. Okay. So we'll strike section 4 from there. On page 8.
What did you decide on section 3?
We understood it. Are we going to try to do a little bit of different verbiage just to kind of qualify that a little better?
As to it being just a verbal, it's not actually a write-up, it's a, and then also, I guess we can refer back to the employee manual that talks about how the supervisor can obviously jump ahead depending on severity as
Okay,
far as
yeah.
steps of discipline.
Would that help clean that up if we put it,
Yes,
added that right?
I think so, yes.
correct.
Okay.
Thank you.
Page 9, section 5, grievance procedure. Step 1, informational meeting. The union representative and management shall meet to discuss and confer about all grievable issues in effort to resolve the matter at hand. Step 2, filing. A grievance form may be filed at any time in regard to a violation of the agreement or department policy. A grievance form filed in regard to a disciplinary measure received shall be filed no later than 7 workdays after the day in which the discipline was given. A copy of the grievance form shall then be given to the department head and the designated representative of the Board of Public Works and Safety for the purpose of evaluation in response to the union representative and employee. Within 15 workdays from delivery of the grievance, the board shall respond in writing to the employee and union representative with their response. C, step 3, examination of board response by bargaining unit, employee, and union. The department employee and the union shall have 7 workdays to review the board response and reply with any further course of action. D, step 4, arbitration. If the bargaining unit employee and union cannot come to agreement with the board or do not find the response from the Board of Public Works and Safety to be satisfactory, the union must then submit a completed arbitration form with the appropriate signatures to the American Arbitration Association and to the DPW member of management. This arbitration form is to be submitted within 14 working days after the written response from the Board of Public Works and Safety. The American Arbitration Association is to provide a list of at least 7 arbitrators, and the parties will select an arbitrator pursuant to the rules of the association. Neither party shall produce evidence at the arbitration hearing unless previously presented to the other. The arbitrator may not consider matters outside this agreement and shall have no authority to delete from, add to, or modify any provision of this agreement. The decision of the arbitrator shall be final and binding on the parties hereto, and the party losing before the arbitrator shall bear the expense of the arbitrator. In the event that the arbitrator finds in favor of the employee shall be made whole in all ways.
Under step 4, where it says DPW member of management, just looking at some verbiage here, should be director, the DPW director, or member of management. How many members of management are there in DPW? 2. Works for me.
Yeah, that's fine. She wanted to add director, correct? You wanted to add director.
Take out that and put director instead, is that what you want?
Director of the department instead of member of management.
I'm going to refer back to the question I asked earlier. Brad is the director of DPW. The Board of Works, I asked you if you would come before them if there was a problem. Now you've thrown in an arbitrator into it. That's actually what the Board of Works is actually doing, is being the arbitrator and ruling on whether something's right or wrong. And so you just complex the matter by bringing an arbitrator into it.
But the arbitrator is, he doesn't have any reason to
Any
decide
ties to the
for us
city.
or for you or for me or.
Well, I think our Board of Works is pretty neutral as far as they're not necessarily in favor of the employee or the director. They're a neutral party that the handbook actually gives them the option to go to in if there's a situation. And I think you're just making the thing a bigger mess than what it actually is by bringing it to an outside arbitrator and so forth.
If,
I think an outside arbitrator actually helps clean it up. It takes it away from our, if we bring something that is frivolous, then that's going to be on us. And, but to bring it to you and say, let's try and go ahead and resolve this, let's give everybody a chance to try and work this out.
now,
But wouldn't that be, say, a next step if you're not satisfied with the decision of the Board of Works? Then you can go into arbitration outside of that?
Yeah. The board is before that.
That's kind of union standard, right?
Right.
Isn't it? Yeah.
Yeah.
now, if the director administers discipline, anything above a verbal warning, if he issues you a written reprimand, okay, he has 48 hours to notify the board, this board. You have the right to appeal it to the board. And this is what we're talking about in step 2. However, the board will meet, and the board could decide not to hear the discipline. And then, if that's it, then it stands. Or the board might decide to hear the discipline. Certainly, suspension without pay and termination would be different, handled differently. But when you're talking about a written reprimand. So keep that in mind. Whether it muddies the water or not, who knows? But you need to keep this process simple when it comes to this.
So Dennis, are you saying we would only consider an arbitrator in the case of terminating employee?
I don't know what the arbitrator would do for us.
And what if the arbitrator was for the employee and we're against it, then what happens?
Well, we would still have the ultimate decision.
Well, I think what the language says is whatever is decided by the arbitrator, we have to live with, or you. And that's pretty typical contract language. That's not new.
Right.
Let's go back to that later.
On, back up on B, step 2, you're pretty broad there. It says designated representative of the Board of Public Works and Safety. You might as well just say the mayor. You know, it should be go,
Not limit you in whatever you.
limit 2,
designate
I mean,
would be,
okay.
If there was
It'd be like a general
responsible.
mailbox to the Board of Works. I guess we can keep that, I guess. All right.
Page 10, Article 6, seniority. Section 1, qualifications. Seniority is for the full-time bargaining unit eligible employee and shall be awarded based on the employee's full-time date of hire, starting with the employee that has the earliest hire date. Section 2, job bidding. Job bidding shall take place every 6 months, April and October, and jobs shall be awarded based on the seniority list. Section 3, daily seniority. Daily seniority shall be determined by the union representatives and the DPW department head. Section 4, overtime. In the event that a need for overtime arises, it shall be offered on a rotational basis, starting with the most senior employee, not previously called for the prior overtime event. When the senior employee either passes or accepts the overtime opportunity, their opportunity to work overtime will not rise again until a complete rotation of the seniority list has been completed.
Let's back on, up on section 2, job bidding. It makes it sound like we have a position opening up every 6 months, or bidding for jobs. You know, if like someone's wanting to drive the trash truck and they want to apply for that. Is that what
Right.
you're talking about?
Yes, every 6 months, the way, and this is not something new, this is currently how we do it, just putting it in writing and things, but every 6 months, what happens is, there's a list of jobs, and you've got your employees with the most seniority, start at the top, down to the bottom, what have you, and we get the opportunity to choose a job. There's a list of jobs that Brad has made up. And let's say I drove the sweeper this past 6 months, and hey, this time I think I want to throw trash, or I want to be a brush guy. If that position is available when it comes to my turn for seniority, I can choose one of those available positions that's left over. And it's just, you know, opportunity for us to.
Okay, so
do
it's
something
actually
new.
what if it's not going to be automatic, you know, shuffling of jobs for seniority, like if, you know, you have more seniority than, say, the current person driving the trash truck.
Uh-huh.
You bid for that job and kick him out because you want to decide to drive that rather.
If he's got more seniority, I can't kick him.
Well, I know, but if he doesn't, you
Okay,
could knock
right, he
him
doesn't
out.
have- If someone's driving that truck currently, and I've got more seniority, when that bidding time arises, I can choose that position. We go
Okay.
before Brad, Brad's got a list of the driving jobs, we walk into his office, we've all got 5 minutes to decide, okay, what job do you want to choose this time around? And it's a good thing as well, just for cross-training employees. You got employees that are able to run multiple things and do different tasks, and not one employee comes into the city of Beech Grove and all he knows how to do is run the chipper truck. You know, it's also a good method of cross-training.
And the bidding process is a pretty standard thing against most unions every 6 months.
Is overtime available to part-time people? Would they go through that process of the, you know, calling one to the next?
I guess that would just be decided once they've, you know, gone through all the full-time guys. And if there's still overtime available, say it's lead collection, which is a very busy time for us and that kind of thing, then I guess, you know, that would just, as far as the part-time guys and things, that would just be up to Brad whether they're offered, you know, overtime and things.
But what I'm saying is, if you're calling and this person gets it this time, you go down the list, next time someone gets it next time, is that part-time person put on the overtime list?
That, I don't think so. It'll be part of the rotational process.
I don't believe they would be.
Are they now? Are they used for overtime?
Right now, are they used for overtime? Yeah, I mean, it's right now, I mean, like if it was leaf season or something, whatever, and we needed extra people, I believe, Brad would offer.
Well, they're capped on their hours, so you would use them as you would need them up to a point. I wouldn't really call it overtime for them. But that's how it currently operates out there.
It would be just extra hours for them.
Well, I mean, we typically try to avoid it because, if you're part-time, you're kind of hired in under the assumption that you work up to 32 hours. So you have them for 32 hours, you try to schedule the work the best that you can when it's the heaviest, but ultimately you really try not to go past that.
Okay.
29 hours now, Brad.
Yeah, starting next year.
Okay, so here's my question. So I'm okay with the job bidding every 6 months. To me, that's just almost in any union shop. But my question is, if we're having a job bidding process, why do we need daily seniority? To me, that has already been done in the bidding process prior to. So why do we have daily seniority?
That's very limited. There's only a few guys that are kind of, I guess they would be just like a floater. There's not really a set job for them. So it would be if a bidded on job, if that employee was off or something like that, the guys that were left to fill that position, that would be where seniority would choose to.
Okay, I got you
that
now.
position.
Okay, I got you now. I understand. Okay. All right. Have we got the overtime yet? Did you read that one yet? Did you read it?
It's been read, we
Okay.
stopped at Article 7.
Okay. So I have a question. This might be for Brad, because to me, I think that rotational basis on overtime is going to be a clerical nightmare for you, but I'm not trying to do your job. My whole thing, to me, seniority prevails in all situations. That top guy has earned the right to that overtime, how do I say it, opportunity.
Yeah.
To me, the senior guy has the right to either decline or accept that overtime. I think that rotational basis, so on Monday, it comes down, say like the first 2 people take the overtime, the next 3 people don't want it, and then the 5th person doesn't, or does. Brad, is that gonna be a nightmare for you, trying to keep track of that?
I already have a pretty good idea when it comes to overtime, who worked it last. So whether I start with the most senior guy or the guy that got the overtime last, it's a starting place either way. In either case, that guy might not want it, and so I might have to start going down through the list, whether I start at the top or in the middle. It really doesn't matter.
Is there a skill level that comes into play as far as that rotation?
And I guess I would probably defer to the union to make that distinction as to whether they want to do it that way. I mean, this is something that they've come up with that I think they feel like gives guys that are further down the list an opportunity versus always going to the same 1 or 2 guys. I don't necessarily have an opinion. My job's going to be the same either way, probably.
Okay.
I'm going to make maybe the same number of phone calls.
Okay.
It really falls more back on them as to who they want to give that opportunity to. I mean, do they want to recognize seniority each and every time, or do they want to occasionally, be able to get further down the list where in some cases it might not?
Okay,
I would obviously, that's a decision they would have to make.
okay. And does skill level come into play with that rotation?
I mean, most jobs that a guy would get called in for to do, everybody can do, with the exception of maybe if you had to drive a trash truck, you would obviously only offer that to CDO guys.
Okay,
Because a
Okay.
non-CDO guy, legally can't operate it,
Okay.
actually drive the truck.
right,
Probably one of the few cases, or calling somebody in to run the sweeper.
okay,
Those incidents would be few and far between.
okay. You're cool with it, I'm cool with it. We're good.
Continue with Article 7, non-discrimination, Section 1, general application. The provisions of the agreement shall be applied equally to all employees covered by this agreement without discrimination as to
We'll
age,
stop.
Gender, race, color, creed, veteran status, or disability is defined by law, national origin, religious, or political affiliation, except where specific age, gender, or physical requirements constitute a bona fide occupational qualification are necessary for the proper and efficient administration of the department, or are otherwise allowed or required by law. The applicant shall share equally with the city the responsibility for applying this provision of the agreement. All references to employees in this agreement shall include both males and females, and wherever the male gender is used, it shall be construed to include both male and female employees. All the terms of this agreement shall be administered in compliance with the Americans with Disabilities Act, ADA, and the department shall take any reasonable action necessary to comply with the provisions of the ADA. Any discussion on that before I flip the page?
You currently don't have any females on staff?
No, not currently on. Section 2.
This was,
I'm sorry.
is this was, this might be a question for you. Are you okay with the general application? Is this pretty much in federal and state statute?
This is general EEO
Okay.
language, sure.
Okay, great.
You know, one thing I'm sorry to interrupt, but interject real quick. This just popped in my head, but it's kind of a real world scenario that I deal with. When it comes to calling people in for overtime, could we put some language in there, or do you guys have any thoughts about, you know, when I'm calling people, and let's say I get a voicemail, can I cruise on to the next guy? Should I wait 5 minutes, 10 minutes? Do you want to give some kind of, because sometimes a guy has to have an opportunity to say, oh, I got a call, and then he may want to come in, but if I've jumped to the next guy, have I violated him? Should we specify his, you know, a time frame before I then move on to the next person?
I think it's fair to you, because you don't need to be sitting around waiting.
Right, a lot of times
30 minutes for some guy to
time is of the essence if we need to bring someone in, so any thoughts on that?
And do you have to have a verifier that you did call?
No, I think at this point, it's just,
Like a
we're
union?
trusted, obviously.
Well, when you talk about a contract, it's really hard to trust. I mean, let's be honest.
I think that we had talked at one of our meetings that to try to align in detail the process that would work for Brad and the guys. That would be too difficult and too wordy. So we think that it might be best if they just sat down and worked something out, some kind of little process that worked for them, as it has been.
So whatever you work out needs to be in writing,
Is there
Yeah.
a
right?
time, Brad, that you feel is,
Well, that's kind of what I was after. I didn't know if anybody had an opinion, because I don't know. I mean, how long do you give a person before you move on and call the next person? You know, I want it to be fair, but at the same time,
No time frame, and it's.
you either take the call or, yeah.
Move on, and if anything, we can make it to where, that individual maybe is just not skipped, or maybe you call them next time.
Mm-hmm.
But, no, I mean, I don't think at any point you should wait around.
Because I know I've had that before. I've called, got a message, left a message, and then eventually moved on, and then got a call back. Well, I've already called, you know, and so I didn't know if we should clarify. It just makes it easier on me sometimes to know everybody kind of knows what the process is, so.
Well, especially in a storm situation, tornado or snowstorm, time is of the essence to
Yeah,
get things taken care of, so.
that's fine with us, Brad.
okay,
Make the call, if they don't answer, move on.
okay. All right,
But we're gonna get that in writing and, or
Just keep that.
qualify that
Record.
somehow? Okay.
all right, thanks.
Page 11, section 2, applicants. The city agrees to continue its present non-discriminatory policy offering equal opportunities consistent with this agreement for available jobs to qualified applicants without regard for their age, national origin, race, color, gender, creed, veteran status, religious or political affiliation, or disability as defined by law, except for specific age, gender, or physical requirements constitute a bona fide occupational qualification, are necessary for the proper and efficient administration of the department, or are otherwise allowed or required by applicable law. All applicants will be subject to drug, alcohol, and driver's record screening as well as a background check before employment with the city. Any applicant who fails these checks and screenings listed above will not be eligible for employment with the city. Applicants receiving employment by the city of Beech Grove must receive all listed vaccinations upon employment. See Article 8, Section 12. All new hire full-time employees are subject to a one-year probationary period from date of hire. All full-time employees are union eligible on day one of employment. See General Ordinance number 6 and 11 for the year 2013. Section 3, personal decisions and actions.
Time out.
Personnel.
Can we talk about
Yes.
section 2 real quick? Sorry. I like that sentence in there. All new hire, full-time employees are subject to one-year probationary period from the date of hire. I think we need to define that a little more. What if I think I'm doing, a really good job and my year's up and it's like, you decide to let me go? I mean, there just needs a little bit more meat behind that.
Well,
To me.
unfortunately, that's how that's always played out.
But am I getting like a monthly or a quarterly update? Am I doing okay? I mean, to me, there should be a little bit of direction if I'm not doing it right, and then cut our ties at the end of the year or prior to that.
You're saying almost like a 6-month review and then
Yeah.
try to steer you in a certain direction or quarterly review.
We should probably have reviews, yeah. I don't know if you
Especially
guys
for-
have them now or
Especially
not.
for a 1-year and
Yeah.
new employee.
Probationary.
Because if you're not pleased with my performance and I'm not getting any feedback, and all of a sudden at the end of the year you let me go, to me,
If you don't have any disciplinary problems.
it's hard to let me
then
go.
it's pretty much
should be
saying that
okay.
you shouldn't
Yeah.
let them go, exactly. I understand where you're
But
coming
yet
from. I
there
think
should
so.
be a review though. And so it could be in their file. So in case
City, right?
something does happen,
Yeah, I mean, that's more incumbent upon the DPW director, I would think.
I mean, I like that. I mean, I do like that. It just needs to be defined a little more.
Is that something that we need to develop? I would think maybe, if not a bi-weekly, at least a quarterly review of the employees' the job performance.
I think we probably should put it in, the manual or, something like
Brad,
that.
do you have anything like that right now?
A review process?
Yes.
Something that we're putting in here this year, I think, is sitting down at least yearly, doing a review. But if you're wanting on a new employee to do it, sooner than that, because obviously 1 year is when we'd have the option of not retaining that employee.
The police and fire have quarterly, for new employees, they have quarterly evaluations.
Should we put in there something, based on quarterly feedback or reviews?
Yeah, because I could see where we're gonna be muddying here, because you're saying a probationary period of 1 year, but this employee also can join the union from day one. I flat guarantee you, if they get rid of this employee, you're gonna say,
You're going to try,
prove
that's a
that
good point,
something's
Ed.
wrong.
Well, also the city has the right after 1 year to discharge. And the city has the right to extend the probation as well. So
So does that verbiage need to be in here?
it is in
It's in
the,
the handbook.
Okay,
Yeah.
okay,
All right.
okay. Sorry, didn't mean to muddy the waters.
Should we reference handbook then?
Yes,
Like
reference
employee
handbook,
handbook,
yeah,
in parentheses or something of that nature?
yeah.
Okay.
Okay, Section 3, personnel decisions and actions. The city agrees that all personnel decisions and actions, including but not limited to training, promotion, compensation, benefits, transfer, layoff, discipline, or termination, will be administered without regard to age, gender, race, color, creed, veteran status, or disability as defined by law. National origin, religious, or political affiliation, except where specific age, gender, or physical requirement constitute a bona fide occupational qualification, are necessary for the proper and efficient administration of the department, or are otherwise allowed or required by applicable law. Section 4, hiring representation. The ASME shall have the right to have a representative present during the interview process of hiring new employees. Section 5, promotional representation. The ASME shall have the right to have a representative present during the promotional process of an employee.
Brad, how do you feel about section 4 and section 5?
Yeah, why would there be a need for a union rep on an interview of a new employee?
Yeah, I guess I'd like to hear
That doesn't make sense.
Yeah, because to me, the city has a right to hire who we want to hire. But then again, you're saying you're only asking, to have a representative there. So my question, right? So my question is to you, Brad, are you okay with that?
Well, I'd like to hear, I guess, what the thinking behind it is.
Okay.
I think sometimes our folks are maybe more in tune with someone who's during the interview process that they might be able to determine, is this person going to be able, am I going to be able to work with, or the other folks going to be able to work with? Maybe somebody might know something about that person that work there. Our place in the interview process doesn't say that we have.
So you're not going to be actually a part of the interview process, but you're more like an influence? Is that what I'm hearing?
I think it was intended to be a part of the interview process, but a silent part. And then discuss with Brad with regards to what input we might have.
It sounds like you're saying you might know more than the director of the city on how he wants to hire,
But it only says they just want to be present. They're not
Yeah,
they're
but
not actually in the decision making. So
I still don't see any need on
Brad, I'm
it.
gonna put this one back on you.
I mean, I don't have any strong feelings, but there's nothing that would go on in an interview process that would be, that someone wouldn't be able to be there and be exposed to it. I think it would come down to, obviously, the ultimate decision would be probably a combination of maybe myself, some input from John, and then if we wanted to seek that person's opinion, and this is someone they have to work with as well, so I get that side of it, but then also that person, they do have the flexibility of not joining the union, so that would be up to the new hire whether they wanted to join or not. I guess they have that, at least that option or that freedom. So I'm not against it. I just kind of wanted to hear.
Shall have the right
I'm sorry.
to have a representative present.
You'll have the right.
What happens if they choose not to?
Would the word may fit that better?
I think it'd be, I think I'd feel better if it would be up to the new hire, the employee, if he'd want someone else in the room.
Well, sometimes
I
as
mean,
an
the- you know,
interviewee, you don't have that choice.
Well, yeah, I mean, I wouldn't want, be pressured on, the possibility of a union person there, and I don't know. It just seems like it's, trying to reverse.
You don't want to say in who gets hired, do you? You just want to observe the process.
Yeah. And Brad asked for Andrew for his input. What did you think about this applicant? And Andrew says, well, I think this is what I think. Then Brad can decide if he wants to use his assessment of that.
Personally, I think it's more relevant in 5 than it is in 4.
And I think just the opposite.
See, in 5, if you have 3 guys that are up for promotion, and you bring all 3 of them in separately, you want somebody in the room who has no say. He has no say. He just goes back and tells the 3 applicants, you were treated fairly. I think that's very relevant.
I think we can strip.
You were given a fair shake.
I mean, I agree with that. I think we could strike the 4.
Strike 4, keep 5.
Yeah.
You know, and to me, if Brad wants, you know, if he wants to bring you guys in, if he really wants your opinion, needs your opinion, let him call you in.
Yeah.
Okay. Any other things on Article 7?
No.
Okay, because Andrew and Rob, we're going to stop there.
Okay.
And we will pick this up at the second meeting in July. Richard, do you want to make comment?
Not really.
Okay.
Just for the board's sake, I'm a, Compton is my name, Leonard Richard Compton in Beech Grove. I go by Richard. I came to this community in 1947, Beech Grove proper 1954. And I still have my mother's residence on South 11th Street. I had seen the mayor, I can't recall where we were when we first started, but it might have been in the park. But we discussed this situation, and he asked if, or inquired if I could be of some assistance to him. Actually, I was a labor representative for 37 years. I want to nobody make any mistake. I'm here on behalf of the mayor and the city of Beech Grove primarily. What I witnessed with the employees and Brad and the mayor is quite amicable. They were just trying to walk through, and perhaps, in my estimation, a collective bargaining agreement is nothing more than a refined personnel policy, so that everybody understands where they're coming from. So outside of that, I have no further comment nor desire to take any more of anyone's time. I deeply appreciate the opportunity to be here.
Rod, do you have any comment, or Andrew?
I just appreciate the time we've taken to sit here and discuss it.
We've had good discussion on both sides.
We don't generally allow, I don't generally allow the public to speak at Board of Works meetings, and I didn't have a sign-up sheet out there. Craig put one out there, and Anthony signed up. Anthony, did you want to comment briefly?
Anthony Davidson, 61 North 14th Avenue. I would just like to go over a couple more things, because this agreement does affect the budget that's actually in place. Mainly the Labor Management Committee, the Health and Safety Committee, where a representative on his or her off-duty time shall be granted overtime pay or compensatory pay. There's a couple things with that. One, you guys approved or went past that, and you guys went to let me find it. The association business leave on page 5 here, where it says in there, but not overtime pay. So that kind of contradicts what you guys just did. Also, I just want to read Indianapolis version of that too, with AFSCME. It says, it is agreed that a representative of AFSCME may be required to attend business functions representing the union and will be granted unpaid leave to do so. Nowhere in here does it say for Labor Management Committee, Health and Safety Committee, that the city of Beech Grove is going to pay. I think that's absurd. You guys need to do that on your own time and not Beech Grove's time. I think calling a meeting to discuss or notifying somebody to get into a personnel file, I don't understand why we have to do that.
Anthony, what page are you on?
That's on page 4.
Thank you. And what was your comment about that, please?
Where we have to notify the unit representative. Let's see, it says the union representatives and employees shall be notified and discuss any additions to the potentially added to the anything potentially added to the employee's personnel file. I don't see why we have to constantly, call somebody to add something in. I mean, that could be, that sets yourself up for anything. That sets yourself up for, we got to notify the union of representatives every time you guys want to change your insurance. That's how I interpret that.
There wasn't to the point.
But it's what, but
And
it's,
what it was is if there is something that is maybe something good to put in an employee's file, he should know it's there. If you're wanting to write something bad about him, he does have a right to know that this is what you said about it in his file. Why would you want to keep it a secret?
the employee does, not the employee, not the union representative. And you didn't state that in here. You stated that anything added in, like I said, insurance. I mean, that's, even though you didn't intend that, you might not have intended that, that's the way it's read.
But that wasn't the intent of the language. Anything that involved other than the group, everybody would know.
That's why I'm coming forward. I know you guys ain't done. These are just my observations.
Usually, if you're going to get in a file, the employee will choose whether or not he wants union representation. I mean, they can choose whether they want the union to represent them or not. Am I right? So it's basically the employee's decision to go in alone or call my union steward in and discuss with me.
That's an and/or.
Exactly. So, I mean, I get that.
I do believe that anytime something's put into the file, the employee should.
All right?
No matter what
Well,
it is,
yeah.
insurance, anything, I mean, and it's an and/or. If that employee says and the union, I guess that's what they want, but definitely, an employee must and/or the union. I don't think it's stating that I want to know everything.
Have to, right.
No, but the employee, I think at all times should know what's going on, good, bad, or indifferent.
Well, I'm not gonna spend all your time on here. I've written numerous notes, and I'll email you guys this. That way you guys can ask that in the next meeting. I just think that this is just absolutely absurd, agreement here, especially on the December 3rd council meeting when I asked the union rep here if there would be any added expense on to the city with this union representation, and his response, and I quote, he didn't know of any money that would be spent on union activities at this time, where it clearly says it right here in this contract.
And where's that at? Show me where it's at, Anthony.
Labor Management Committee, Health
Tell
and
me
Safety
page.
Committee.
Mike,
I'm sorry?
what
Oh, I'm
page?
sorry, it's page 3.
The intent for that writing down there is not that we are going to have a meeting. The meeting is between us, Brad, these two here. If they call a meeting on our time or something like that, then that's when we're paid for that time. If it's a meeting that we're holding ourselves, but no, there's no overtime being granted or something like that. But if it's where that comes into play is if it's requested on by the city for us to meet for that, then it will be done during work hours on a request.
Well, yeah,
So it's a
but see, this
situational
contract
base,
didn't
right?
go into effect until 2014.
Right, it's a
So after
situational
the
base.
next budget.
Right.
So what we're talking about right now doesn't,
So you're setting us up for a budget shortfall then?
well, we don't know. That's what we're still negotiating and talking about here.
The Labor Management Committee is formulated with regards to if Brad has an issue with something that's not being done, and he wants to say, let's sit down and talk about, this is what I want to do, can this be done, let's do it this way. So it's Labor Management Committee, it is not a union committee. And if Brad wants to call a meeting, then he should have the right to do that, and to talk to the folks about how to get something done efficiently and better.
But if it's a labor committee, then why are why does it say, union involvement?
Because it's
Labor.
labor.
But there could be others that come forward that are not union, that don't want the union representing themselves. Do they have a say?
If they're going on the committee, yeah. And it's not a question
All I'm going to say is that I'm 100% against this. I just wish you guys would just go back to the drawing board with this. A lot of work needs to be done with this.
And that's what we're working on.
A lot.
That's what we're working on.
But you guys just passed, quite a bit of stuff that,
I disagree with you, Anthony.
We haven't passed
Okay.
anything yet.
but you guys passed through. I mean, it was read to you guys, and you
It's
guys
first
just kind of bypassed it.
Yeah.
But I had one citizen, I've had several citizens, but one citizen said something to me that just stuck out in my mind. Did Beech Grove hit the lottery? Because that's what we're acting like. Thanks.
All right. Any other comment by any of you folks?
Okay, just for notes, where we left off, where we're picking up, we still need to go back to the arbitration discussion.
And when we come back, could you, Andrew, provide us with a clean copy?
Yeah.
And take out what we've decided to take out? Then we will reconvene on July the 15th at 7 PM here for this. And I need a motion to adjourn.
I'll make a motion to adjourn.
And I'll second.